Welcome back to the Emily Show and happy Monday. We have a whole lot we need to talk about today. We've got updates on the Bryan Kohberger case that happened literally after I finished streaming about the case last week. Updates in the Lively Baldoni case with some fights going on over Blake Lively's deposition and what's going on there, and a new hearing that's just been put on the docket because of that. Some Tom Girardi updates, some Tom Girardi, Erica Girardi updates, and then a whole bunch of new information in the Karen Reed case that we're going to get to. Some of that we're going to dive into more in depth on Tuesday's live stream. But for an overview today, that's what we're going to overview. Emily, that seems like a lot. It's a lot, but I can't go an entire podcast episode before we stream without talking about how much Hank Brennan got paid and without talking about this letter that Alan Jackson sent regarding Officer Dever. The police chief would get my last name right, she said in testimony. And then the police chief is like, who's this girl? We're going to have to talk about all of that and whether or not she should be on the Brady list. We're going to go through some of it today, some of it on Tuesday, but there's so much to talk about. And that's not even getting into Karen Reed's movie deal and book deal and the civil case and the rest of it. So buckle up. It's going to be a fast and jam-packed podcast. So let's go. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. Okay, first of all, for the 7 of you that are going to be in the comments being like, Emily, what about Donna Adelson? Yes, it looks like Donna Adelson is still scheduled to go to trial in August. Yes, if she goes to trial in August, I will be covering it. Don't worry, we will be doing updates on the stream this week. That is a solicitation of murder and murder case out of Florida. She's one of the last defendants to be tried. We will do more Adelson updates. She was just in court Friday. We're waiting for orders from the court. Don't worry, we'll talk about Adelson on stream. It looks like it's on track to go to trial in August. So get the Lawnerd app, buckle up if you want to see that live trial. But this case has been ready to go to trial a number of times and hasn't. So it's not one of those cases where I'm like, we're going to trial, block your calendar. It's one of those cases where I'm like, I'll believe it once they've swear a jury in, because I'm not going to believe it till I see it with that one. But speaking of updates that we got after live streaming on Thursday, we were talking about the gag order or the non-dissemination order in the Bryan Kohberger case. And the court dropped an order after I finished streaming, because why wouldn't that happen? We need to take a look at it real quick. For those of you that did not have a chance to catch stream, don't worry. The media coalition that interceded at the beginning of the Kohberger case has asked to intercede again and said, hey, Your Honor, so Bryan Kohberger no longer has some of the rights to like a fair and impartial jury that were part of the concern when the court issued this non-dissemination order, or gag order as it is more colloquially called, because there's not going to be a jury trial and he waived all his appellate rights. So could we please interview people? The media is like, we have a right to interview people. We would like to do that. A lot of them are covered by the non-dissemination order. And we had a conversation about that in the case law and the motion that they brought, and the court set this for hearing. What's interesting is the court did say at the plea, hey, can I just vacate or withdraw the non-dissemination order now? And the prosecution said we would actually like to keep it in place. And it was really for, well, lack of annoyance from the media, my summary. And the court said, okay, well, we will keep this in place through the sentencing later this month on July 23rd, maybe going into July 24th if needed. And the media coalition is like, excuse me, Your Honor, that's not a reason. So we would like this lifted now. The court set a hearing for it. So the court has set a hearing for July 17th, 10:30 a.m. This is going to be a Zoom hearing. And I would be surprised if the court didn't just lift it that day. There doesn't seem to be any actual legal justification for keeping this in place at this point. The legal balancing between Bryan Kohberger's rights and the media rights has shifted substantially since he has pled guilty, since he has waived his rights. I think the court might lift it that day. I don't even think he'll wait for a written ruling. So we'll see what happens. I will, of course, be on a plane when this happens, because that is the way it happens. But I will be recording this hearing. I will give you an update in the Lawnerd app. And then if we need to go over the hearing prior to the sentencing, we will. I just think it's going to get lifted and we're going to see more media interviews. So we'll see what happens on the 17th. And speaking of July 17th, that day might stick out in your mind because that is the day that Tom Girardi is supposed to surrender himself to federal prison. Remember, Tom Girardi had gone to trial and then been sentenced in the federal case that largely surrounded taking money from clients. He has been sentenced to prison in that case. He was supposed to surrender himself on July 17th. Well, his lawyers would like to put a pause on that, but they set the hearing for after his surrender date and didn't ask the court to vacate the surrender date. So the federal judge is like, he's supposed to surrender July 17th. What are we doing? Well, Tom Girardi's lawyers are asking that pending his appeal, he remain out of custody. We have seen this in other cases where this request has been made. In some cases, it's granted. In some cases, it's denied. Given the length of sentence Tom Girardi was sentenced to, I think it's possible the court says no, he can appeal while he's in custody. And just looking real quick at the court's formalized sentencing sheet, he was found guilty of 4 counts, and he was sentenced to the Bureau of Prisons for 87 months, which is a bit over 7 years. That term is not a term that's going to be entirely served during the course of an appeal. If he had been sentenced to 5 months, there's the very real possibility that his appeal would take longer than any sentence. That's not the case here with 87 months that he's been sentenced to. So they might well have him surrender himself still. But let's look at what his defense has asked. What we are looking at is a minute order from the court from July 10th. And the court said, hey, defense, you filed a motion for bond pending appeal and self-surrender date, meaning we want Tom Girardi to stay out of custody while his appeal is pending. And an appeal pending can take a year to multiple years. The court says, pending before the court is defendant's motion for bond pending appeal. The court said that the defendant did not file the motion until a month after the court issued its judgment and commitment order, which is what we just looked at, and required the defendant to self-surrender on July 17th. So the first thing the court is saying is, why did you wait so long? You waited a month. Defendant noticed the motion for hearing on August 14th, which is 1, after defendant's surrender date, and 2, not a hearing date cleared by the courtroom deputy clerk as required under the court's procedures. You can't just put dates on the calendar. Could you imagine going to your hairdresser and just being like, I'm just putting a date on your calendar. I'm just going to show up then. You have to clear it with somebody. You have to ask for a date. You don't get to just set dates. So the court is like, first of all, this August date is after the surrender date. Do you want him to surrender to prison, go through the process of being checked into custody and housed, and then be released from custody on bond pending appeal? Like, what are we doing? And then you didn't even clear the date with my calendar. So that's not going to happen. The court goes on to say the notice of motion indicates that the government will oppose the motion. Of course, the government's going to oppose the motion. The prosecutors are like, go to prison now. The notice specifies a due date for opposition by the government and specifies a due date for the reply brief of August 25th, which the court assumes is erroneous and that the defendant meant to specify July 25th. The court is saying you can't have a reply brief date of August 25th if you have a hearing date for August 14th. So the court's saying even in this, there's a typo. And we think the defense meant to set these dates for July 25th. It goes on to say that the parties are directed to confer with each other to identify hearing dates when counsel for both sides are available thereafter, and no time later than July 14th, which is the day this episode releases, counsel must consult with the calendar clerk and clear a date and time identified by all counsel as an available date and time slot. The court goes on to say the defendant's July 17th self-surrender date is before the briefing on defendant's motion is expected to be complete. The parties have not addressed the issue of defendant's self-surrender. The court therefore directs the parties to confer regarding the issue, which means the briefing won't be done until after he has to go to prison, and present it to the court no later than July 14th. So we'll see what happens on Monday. Will Tom Girardi have to report himself to prison this week? But also, if Tom Girardi reports to prison this week, it's going to cause further complications for the Tom Girardi, Erica Girardi divorce. And you might have seen headlines about that. I know there are other housewives in headlines regarding their divorce. If you want me to take a look at what's going on with the Denise Richards divorce, please let me know. I think some of you have watched that relationship play out on Real Housewives of Beverly Hills. Let me know in the comments if you want me to cover that one too. We're not going to do it today, but there are issues with the Erica and Tom Girardi divorce because right after the divorce was filed, and it was filed on like election day 2020, I think Erica was hoping it would like scoot right under the headlines. And it has been pending since November 3rd, 2020. But Tom Girardi was put into a conservatorship shortly thereafter. We have had lots of conversations about that. And then the bankruptcies popped off. Then the criminal case popped off. Now he's been convicted in the criminal case. Now he's pending prison. And the divorce still isn't resolved. And the bankruptcy cases are still not completely done. So what's going to happen with that divorce case? Well, the judge is like, why is this still on my docket if you all aren't doing anything? So the divorce case runs the risk of getting thrown out because Erica Girardi and Tom Girardi are still legally married but separated. So the court had set a hearing date for June 26, 2025. Erica's attorney showed up at the hearing date. The court called the matter for hearing. We have no indication that Tom Girardi has ever appeared in this case or had an attorney appear in this case. The court set an order to show cause regarding failure to file dismissal or judgment on August 1st, 2025 at 8:30 a.m. So petitioner Erica Girardi's attorney needs to file their dismissal or judgment or show cause why they haven't been able to dismiss the case yet. And I think one of the big issues here is that Tom Girardi is in a conservatorship. So the attorneys have to move forward, and no attorney, it seems, has appeared in this for Tom yet. But how do the attorneys move forward in settling out the estate? Though this has been pending since 2020, at some point it might just need to turn to a contested divorce filing and have the court just order them divorced. But it is 2025, and this has been pending for years with very, very little docket activity. So I understand why the court is like, what are we doing and why aren't we moving anywhere with this case? Nothing has been filed that needs to proceed forward for a divorce, but there's also not really a division of the assets in this case because the bankruptcy for the personal bankruptcy of Tom Girardi and then the bankruptcy of the business has all of the assets into an estate. So it'll be interesting to me to see how they try to navigate the divorce. And for Erica, who at this point I'm sure just wants to be divorced, how do you divorce someone that's going to prison in a conservatorship and all of their assets are locked in two different bankruptcies? It seems like a nightmare hypothetical from my 3L year of taking family law. I'm not sure where the courts are going to go with this, but I'm interested to see how Erica's attorneys present this or whether the divorce filing just gets dismissed and they have to start all over. Because at some point, they have to be able to dissolve this marriage. And I'm not really sure where they go from here. It's really a very factually difficult case because of all the things going on with Tom Girardi. Though I'm sure Erica really just wants it to be done, I'm not sure how they're going to get it done with regard to this divorce. So I'm going to keep an eye on it. Let me know if there's other housewife divorces you want me to take a look at, because we've been covering so much criminal law. We haven't had as much time for the more civil aspects, but they've been catching headlines one right after another. So we can do more housewives in a minute. Today we have other civil stuff to talk about though. But speaking of civil cases with upcoming hearings, the Baldoni Lively litigation is still very much full steam ahead. The last time we talked about this case, I talked about the fact that the court had dismissed Justin Baldoni's claims and allowed a carve out for a few of those claims to be refiled by the end of June. Justin Baldoni's team did not refile those claims, which means there is no pending countersuit to Lively's suit. At the time when I took a look at that, my comment, I think, was somewhere along the lines of most of the things that are in Baldoni's countersuit are also defenses against Blake Lively's suit. So even if there isn't a countersuit, all of the facts that he alleges, the actions that he alleges, and the scenarios that he alleges are going to come up in the course of defending against Blake Lively's suit. It's just whether she's also being sued by him or not. The facts are still going to come forward in the course of the case because a lot of it is basically an answer to her claims saying she says this, but we say this. So he chose to not refile those. And his attorney gave a statement. I found it through Good Morning America. Attorney Brian Friedman, in his statement, said that instead of revisiting the existing claims, our clients will be pursuing additional legal options that are available to us. The court's decision on the motion to dismiss has no effect whatsoever on the truth that there was no harassment nor any smear campaign, and it does not in any way affect our vigorous defense against Ms. Lively's claims. Discovery is proceeding, and we are confident that we will prevail against these factually baseless accusations. Lively's spokesperson responded to that statement and or decision by the Baldoni camp saying, the court dismissed the frivolous $400 million Baldoni Wayfarer lawsuit in its entirety. They added that in the days that followed, Baldoni's lawyer said the judge's decision to dismiss their case was not a big deal as they promised to amend and refile it. As per usual, the statement goes on, that was not true. The court's dismissal of Baldoni's sham lawsuit was a total victory after all. Both statements are advocacy in the media. The allegations will still come forward as Baldoni has made them in defense, but on Lively's side, they are not facing damages that would go to Baldoni. However, that doesn't mean things like lawyers' fees and what have you can't be pursued down the road. There are other legal avenues, but at this point, there are no countersuits left. The total victory in the dismissal of the Baldoni suit is for the New York Times, because the New York Times is largely out of this now and has a much better standing to fight discovery. So if anyone's claiming like ultimate victory, it really is the New York Times in this. But when they talk about discovery being ongoing, it sure is. And there is a hearing set for July 15th over discovery because the Baldoni parties through their lawyer and Lively through her lawyers are fighting over Lively's deposition. Does this shock anyone? No, it doesn't. But there have been numerous motions for protective order, and it seems the attorneys can't even agree on where to hold Lively's deposition. So we are going to see more discussion of that deposition after the court's hearing on July 15th and more fighting over who will be allowed, what the protective order is. And Lively's team points out statements made to the media by Brian Friedman that is part of their filing. I think these statements were largely hyperbolic, but they are treating them as literal. So we got to talk about that for a minute. Taking a look real quick at docket 415. Yes, we are over 400 docketed items in this case that is set for trial, still a little less than a year from now because it's set for March 2026. So discovery is full steam ahead. Discovery is not something anyone enjoys, except for maybe content creators if they ever got to do discovery on the other side of a case that didn't have a protective order. I could see people being like, show me all the things. Lawyers get to bill a ton of money for discovery. But for the parties involved, discovery is invasive. We are at the stage where discovery is ongoing, including the setting of Blake Lively's deposition, which generally are limited to about 8 hours, but that can change depending on jurisdiction. It can be extended. Blake Lively is the center of her lawsuit against the Baldoni and Wayfarer parties. The other side gets to sit down with Blake Lively through their lawyers and ask a bunch of pointed questions to be, well, answered truthfully under oath. It is a process that generally goes after a lot of the documents have been turned over so you can confront somebody about those. And of course, there is ongoing fighting about where that's going to take place, how that's going to take place, who's going to be there, and a protective order. A protective order over a deposition doesn't surprise me to prevent video of deposition ending out in the public, especially in a high-profile case. Though if this does go to trial, then we can see video of deposition come up at trial. In fact, it seemed like it was about half of the trial of Det v. Heard where we saw videos of depositions. And I point to that case because we haven't had very many high-profile civil cases where you actually see video of deposition coming up. In Det v. Heard, a lot of video of deposition and a lot of edited down video of deposition in ways that you're like, wow, that jump cut was uncomfortable. Remember, there were days of court where the parties were just making objections over answers to depos and cutting out from this timestamp to this timestamp. Yes, like that. Let's take a look at the objection. This is the objection from Lively's team in docket 415. This was filed on July 11th. This is coming up for hearing on July 15th, and then we will have some answers. This is the redacted public version. To the judge, Plaintiff Blake Lively respectfully moves the court to enter a protective order directing defendants to 1, conduct Ms. Lively's deposition currently scheduled for next Thursday, July 17th at redacted location, and 2, disclose the identity of all individuals who will appear. Ms. Lively regrets the need to burden the court with this request and does so only after defendants have refused Ms. Lively's reasonable request and insisted instead that Ms. Lively's deposition take place at location redacted. They go on to say defendants have not denied that their intent is to manufacture a harassing publicity stunt by requiring Lively to parade through paparazzi or by inviting unknown attendees to the deposition, including members of the media or social media influencers or any other number of abusive tactics. I can't imagine a deposition literally attended by members of the media or social media influencers. I just can't imagine that's the case. They go on to say, despite Ms. Lively's repeated efforts to confer, defendants have refused to address these concerns and have responded only with their insistence that they alone control all logistics and security issues. Defendants' failure to acknowledge the real security and privacy risk ignores that they have engaged in retaliatory harassment that has extended into the litigation itself, including by defense counsel's repeated and personal attempts to turn Ms. Lively's deposition into a media event. They go on to say, good cause exists to provide Ms. Lively with these basic protections, and then they turn to the Federal Rules of Civil Procedure 26C1. The court may, for good cause, issue an order to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Now, if Lively's side has security and they're not requiring the other side to bear the cost of security, it seems that the court wouldn't have a problem with that, saying, okay, well, if you're bearing the cost of security, that's fine. However, if they are fighting over a deposition being taken in California versus a deposition being taken in New York, that can be a huge issue, and it's redacted, so I don't know. This is a federal New York case. However, it would be much easier to fly Lively to California to do the deposition than to fly most of counsel's entire office to New York to do the deposition. Because even if only one attorney is doing the deposition, other attorneys will likely be working at that deposition, going through pages of things as questions get answered to see if there are follow-up questions that need to be answered. So wresting a law firm out of the state where they are is something that they might want to fight over. That said, do attorneys fly all over the country to do depositions all the time? Yes. On any given flight you're on, there is probably an attorney going to a deposition somewhere. But I don't think plaintiffs can require defense to bear the cost of security. And security is probably something that is required just given the celebrity nature. However, if the location and date of the deposition isn't known, then it's probably less of an issue. But the date is now known, and I'm sure Lively's side is concerned that somebody knows the location. Continuing on, Lively's attorney says that Lively respectfully requests that the court order defendants to respond to this motion on an accelerated timeline. Since virtually the inception of this litigation, Lively's lawyers say defendants have used even the prospect of Lively's deposition to generate press interest. Defense counsel publicly demanded, quote, the earliest possible deposition of Ms. Lively in advance of the first court hearing on January 30th, 2025. I feel like we've lived 700 years since then. Counsel goes on to say, resulting in a predictable wave of sensationalized press coverage. They go on to say on May 8th, 2025, Mr. Freeman made unprofessional comments, that's commentary, to People magazine about Ms. Lively's deposition, preposterously declaring that he wanted to hold it at MSG, Madison Square Garden, and sell tickets or stream it. It's hyperbole. Maybe it's not. Let me know in the comments. Would Bryan Freeman be like, you know what? Let's turn it into a pay-per-view. But it's a deposition. Some of the things said in deposition are going to be objectionable and aren't going to come in before a trial. It runs the real issue of poisoning a potential jury pool. Like, you can't do that. I think it's hyperbolic with Bryan Freeman saying, we want this case to be as transparent as possible. We are willing to just let everyone see everything and let the public judge for themselves. Of course, that's not how the rules of court work, but I just think it's hyperbolic and I don't think it's literal. Also, under the rules, it's not practical. And Bryan Freeman knows that. Like, Bryan Freeman knows you can't do this because eventually a jury is going to have to be selected in this case, and nothing could poison a jury pool more than streaming a deposition where things said in a deposition aren't necessarily evidence that'll come in at trial. That all gets fought over later. In a deposition, you make objections, you hold the objection for the record, and you get the answer. If the answer is to an objectionable question, then it will get clipped out before a jury sees it. But if everybody sees the entire deposition, then it runs the risk of poisoning a jury pool. So the court would never allow this. This isn't going to happen. But also, I just can't take this seriously as this attorney is literally going to sell pay-per-view streaming tickets to Madison Square Garden deposition event. It's not literal, but we have seen these attorneys taking each other to task in front of the court over things that they've said in the press, and this is just the continuing pattern of that. I'm sure it grabbed a lot of headlines. Lively's attorneys go on to say that Friedman said, if Lively is, quote, willing to sit for a deposition, I'm available. How does tomorrow morning work for her? Footnote 1, and then it links to a people.com article. They go on to say just days after defendant's notice of Lively's deposition, Friedman sat for a lengthy interview with TMZ in which he announced, I've noticed her deposition. It's set in June. We're going to see if she's going to appear at that deposition or not. Footnote 2. Footnote 2 links to what looks like the longest hyperlink to TMZ ever, and then hyperlinks to other stories covering TMZ stories, because that's how it is. During a conferral on June 13th, 2025, defense counsel insisted that Lively's deposition must be the first deposition taken. Declaration at 3, footnote 3. Lively agreed and offered July 17th, which defendants accepted. On July 7th, Lively's counsel emailed to confirm the plan for the upcoming deposition, consistent with the practice adopted by the parties for other depositions scheduled to date. For security reasons, and this is Lively's counsel quoting the email that they sent to Baldoni Wayfarer's counsel. For security reasons, Lively's deposition will be held at redacted. Separate and private breakout space will be provided for attending parties and counsel, as well as lunch and refreshments. We are happy to coordinate logistics and redacted with the court reporter and videographer, if you would like. For security reasons, we will require a list of all persons who wish to attend the deposition by no later than Friday, July 11th. We can see why this is back in court, where they are saying we have not gotten the feedback that we would like on that. We have not gotten the list of parties attending. But if they are providing the location and the security, I'm interested to see what the rest of the objections are. But also, it's the noticed deposition from the defense. So there are things they get to control in that, including who the court reporter is, who the videographer is. Yes, there is a videographer to depositions. We've, again, seen those in court. They are videotaped. They go on to say that opposing counsel responded by insisting, without any articulated reason, that the deposition take place at location redacted. Ms. Lively's counsel immediately responded that they made security preparations to hold the deposition at location redacted, an approach that aligns with more redactions. Defendant did not respond. Lively's counsel sent another email the morning of July 10th asking for confirmation whether you would agree to conduct the deposition at location and identify all attendees in advance no later than tomorrow evening. That evening, counsel for Lively emailed again saying, quote, you have not agreed to our reasonable request. Well, they probably don't see it as reasonable. So now it's before the court. You have not agreed to our reasonable request to hold deposition at location, nor to advise us in advance who will be present at deposition. You have provided no reason for refusing these basic courtesies, so we can only assume that it is because you intend to make a media show of Miss Lively's deposition in some way, both inside and outside of the deposition room. Opposing counsel responded virtually immediately, writing, we expect to see Miss Lively at 9 a.m. on July 17th at location for her deposition. Defendants have not attempted to demonstrate that cost, convenience, or litigation efficiency warrants holding deposition at location rather than location. These are all redacted. I think that's appropriate. They go on to say, nor can they. Location and redacted. So defendants cannot claim any greater expense. I wonder if Lively's team is offering to pay or if it's same. They say defendants in good faith can't claim the need to hold deposition at location, given Friedman's willingness to conduct it at Madison Square Garden. They're using his hyperbole against him. They're like, well, and I don't know if location is in California or not in California, or if it's in New York or what have you. It might be that they're saying the defendants can't claim that they don't want to hold the deposition in New York. They need to hold it in California, given that he was willing to hold it at Madison Square Garden. You can't take things that are hyperbolic and try to make them literal. Like, stop trying to make fetch happen. The court doesn't sit here thinking that he literally meant he was going to take a deposition in Madison Square Garden. And they're like, he was willing to come to New York. They say holding the deposition at location will save defendants resources because Lively's counsel has already engaged with professionals to ensure safety and professional conditions, including, and then a bunch of stuff is redacted. Defense counsel's insistence that he can take Miss Lively's deposition anytime and anywhere belies any claim that now holding the deposition at location is essential to convenience or efficiency. So they are just trying to hold everything Bryan Friedman said in the media against him, being like, well, he told the reporters or whoever that he's ready tomorrow morning, Your Honor. So why can't he just do it the way we want to do it? What's the problem? So the fight over where Lively's deposition is going to be held is ongoing. It's going to be back in court on the 15th. The deposition is still noticed for the 17th. Will that deposition date get pushed back because of all of this? Maybe we'll find out more on the 15th. I will keep you posted on that hearing and the fight over this deposition. But no, depositions should not become a media circus. No, they should not become a situation where any party to the deposition feels harassed or unsafe. Also, defense counsel has the right to have their team there. They have the right to have paralegals there. They have the right to have multiple lawyers there. This is a large litigation with a lot of parties involved because it's not just Baldoni. It's Baldoni and Wayfarer and the PR agents. There's a lot of defendants here. So no, it shouldn't be a media spectacle, but also the defense is not completely without rights because it's the deposition that they are taking of the plaintiff who chose to file the lawsuit. I'm interested if the court just calls everybody in on this hearing and says, knock it off. Where are you holding the deposition? Do not give anyone notice of where it is other than the immediate parties, and that's it. Are we done? But Lively's attorneys go on to say that they need a protective order. A protective order is not inappropriate here to make sure that the contents of the deposition are not leaked, but that has to be crafted so that there can still be motions made. Things that come up in a deposition might need further motions made to get other discovery. So it's how that order is going to be crafted and how to prevent risk of security issue, because again, someone needs to be able to sit for a deposition in a way that they can go through this experience that's not going to be pleasant, knowing that this is going to be used properly in the litigation. But you can't say a deposition won't be used against someone. That's what it's for. It's for them to answer the questions that the other side has. But it shouldn't be just leaked or wholesaled out to the media after that. This will come to light if it goes to trial. Again, worrying that it's going to become a spectacle of some sort, the court can put an end to pretty quickly. Lively's attorneys go on to say defendants have not refuted that manufacturing public spectacle is their motivating factor in refusing Lively's requests for redacted. Unable to host Lively's deposition at Madison Square Garden or sell tickets to stream it, defendants appear to seek another public relations moment or to create conditions for intimidation or harassment. Lively respectfully asked the court to enter a narrow protective order to minimize security and privacy risks and to preclude defendants from using these proceedings to promote public scandal. And that is quoting the language that the court has used in the past, where the court has said, all of you stop. And particularly, we are not using court record to sensationalize this case. So, do I think that this case will proceed smoothly? No. I think this is going to be highly contentious litigation. It is going to remain highly contentious litigation. I don't think that's going to change anytime in the near future. I will keep an eye on what's going on. I will let you know what happens at the hearing on the 15th. We will see. Will that hearing be streamed? No. Will audio of that hearing be recorded and put out on the internet? No. That hearing will not be streamed. Federal court is not streamed. Do I think people will probably be listening in to that hearing or attending that hearing in person and reporting on it? Yes. So I will let you know what happens after the 15th. Hey Law Nerd, a quick break to thank our sponsor, OneSkin. You've heard me talk about OneSkin in the past and the fact that they make incredible products that really take all the steps out of skincare. And now they have a sunscreen line. I wear sunscreen absolutely every day, even when I am indoors, because I sit very close to a window when I stream. And the older I get, the more I appreciate aging gracefully, and sunscreen is a huge part of that for me. But what I love is that OneSkin also has a formulation for lips. And you know that OneSkin is formulated by a team of female scientists who are not just looking at protecting your skin, but also how to undo some of the damage at a cellular level. I appreciate that the SPF comes in tinted or untinted and is water resistant. Plus they include antioxidants like vitamin C and the proprietary OS1 peptide right into the formula. So if you're looking for skincare that's also sun care, now is the time to try OneSkin's sun care line. OneSkin is the world's first skin longevity company. By focusing on the cellular aspects of aging, OneSkin keeps your skin looking and acting younger for longer. So for a limited time, you can try OneSkin for 15% off using code LawNerd at oneskin.co. That's 15% off at oneskin.co with code LawNerd. And after purchase, just let them know the Emily Show sent you. Remember, oneskin.co, code LawNerd, or you can hit the link down below. Let's get back to today's episode. We need to talk about not the continued contentious litigation in the Baldoni case, but what we are continuing to learn from the Karen Reed case. Because, oh boy, it's a lot. And we are going to cover it much more in depth on live stream on Tuesday. So be sure to pop over to the Emily D. Baker live stream channel. But there are a few things that we just have to chat about because I couldn't wait till Tuesday. So in talking about the Karen Reed case, we need to talk about how much money the taxpayers have paid. And yes, we will be talking about this more, but what I was not prepared for was how much Hank Brennan had billed the taxpayers of Massachusetts and Norfolk County. Because when I saw this article from Boston 10, I was like, what are you talking about? I became Jennifer Lawrence on the Hot Ones going,
what do you mean? What do you mean? What do you mean?
Because this headline that special prosecutor in Karen Reed trial billed DA's office over $500,000 is not including everything. This is for Brennan's time. Over $500,000 for Brennan's time for one trial. Emily, is that how much prosecutors make per trial? No. Is that how much prosecutors make per year? No. No, not even close. And this doesn't account for how much was Aperture paid? Over $400,000. So between Brennan and Aperture, we are at a staggering amount of money. How did the contract with Brennan allow for this much money? Because if he was working for the DA's office for a year, I understand paying him essentially the salary that a line DA would get for a year. Let me make clear though, for most line DAs, if you are working for the district attorney's office, you're not handling one case. There are some circumstances where you might be handling a few if you are just handling some very large trials, or even the circumstance where maybe you are just handling one trial. So it can make sense to me to pay Brennan the salary of a line prosecutor with his commensurate experience. You're not going to convince me that any line prosecutor in Norfolk County is getting paid $500,000 for one trial. It's just out of line for me with what you would be paying for prosecutors. And I have no idea how they approved this. And I still don't understand why the prosecutors of Norfolk County couldn't have done this in office. There was never a conflict declared where they couldn't cover this case and it needed to have someone else prosecute it. We never got any explanation of why a special prosecutor needed to come in and handle this. This isn't the most complex case that we have ever seen in the world. There's no explanation for why this amount of money needed to be spent on this case. And my frustration in that is you have an entire office of prosecutors. According to mass.gov, the Norfolk District Attorney's Office has approximately 130 employees. It doesn't break down how many prosecutors, but it says 130 employees and around 20,000 cases annually. A substantial number of that is going to be attorneys. We are not talking about an office with 7 people. This is a 130 person office. So not all of those individuals are going to be attorneys, but there's a lot of attorneys at that office. So why are we paying Brennan over $500,000? Also, kudos to Boston 10 for following the money. Keep following the money. I want to know about all of it. Mention it all. Mention all the money. Invoices stamped by the district attorney's office show Brennan billed a total of $566,000 between September 17th of last year and the end of the trial, June 18th. Brennan charged a rate of $250 per hour for 2,264 hours. I don't take issue with the $250 per hour rate. It's actually probably lower than his normal rate. And attorneys bill well upwards of that per hour. My issue is that the trial wasn't done on a contract. Lawyers work a ton of time. Prosecutors don't get paid hourly. So when prosecutors are working their ass off on a trial, they aren't getting paid hourly. They're on salary and they're exempt. So you just work until the work is done. I'm surprised this wasn't on a contract. And I thought that it was on a contract that limited the amount spent. Not only did he bill upwards of $500,000, Brennan is the one who seems to have brought in Aperture at over $400,000. So between Aperture and Brennan, we're at $1 million prosecution, and that's just getting started. We haven't even talked about police overtime. We haven't talked about overtime for any of the officers working in the case. We haven't talked about the rest of this. This is in addition to the DA's office normal operating budget. Where can you just throw $1 million on top of somebody's operating budget and have it be cool? Hey, Norfolk DAs, have any of you gotten promoted? Anyone got a cost of living increase? How pissed must the Norfolk County DA's office be? And if you want to tell me, I won't tell anyone. We'll keep you anonymous. My email's open. Tell me. I would be outraged. I can't imagine the LADA's office bringing in special prosecutors because the office is so large, but I can't imagine how outraged the line prosecutors must be. I can't imagine how outraged the voters and the taxpayers must be. Boston 10 says at the end of the trial, the NBC 10 Boston investigators estimated based on data then available that Brennan's price tag would likely exceed $500,000. By comparison, the lead prosecutor of the first trial, Adam Lally, receives an annual salary of $149,000. His boss, Norfolk District Attorney Michael Morrissey, is the highest paid person in the office with a salary of $223,000. That doesn't surprise me that the elected DA has the higher salary. It doesn't surprise me what Lally's salary is. It's probably higher than some prosecutors elsewhere in the country. It seems that he is one of the more senior prosecutors in the office. So if you're paying Brennan roughly what the salary is for Attorney Lally, I'm not going to lose my mind over it. This is wild. They go on to cite Michael Coyne, NBC 10 Boston's chief legal analyst, who said that he expected Brennan's pay to be higher because it's not uncommon for attorneys to work 16-hour days during trial for things like witness preparation, document review, and analyzing research science. I mean, yeah, lawyers work a fuck ton when they're in trial, but prosecutors' salary doesn't change based on how much they work during trial. So I would have thought there would have been a cap to this. NBC 10 goes on to point out that Brennan's first contract called for a maximum payout of $75,000, but it's been amended several times. The most recent amendment was a maximum of $300,000 in early April. Who approved it? Who approved going over $300,000? You remember when we went through the insurance payments to some of Amber Heard's attorneys, the insurance contract said, look, this is the amount we're paying you for trial. You can fix a contract being this is the amount, and that's capped. You're not getting paid hourly for this much time. It's substantial. They go on to cite the amount that Dedham Police spent paying the department overtime and staffing to have security at the trial. And Dedham Police said that they spent nearly $91,000 to provide security to the trial this year, but spent more than $84,000 on the trial last year. So even Dedham has paid a couple $100,000 in security that they were providing to support the trial. Brennan paid over $500,000 for the trial. Aperture paid over $400,000. We haven't even seen all the price tags for local police yet and how much they spent in security and overtime and staffing. And that's not just at the courthouse, but getting the jurors back and forth and the rest of it. The amount of money that has been paid out is substantial. I don't know how the budgeting works for Norfolk County. I don't know if that has to be approved by a board or a board of supervisors, but I imagine the taxpayers are going to be asking those questions because I'm sure that they want to know. And I'm glad Boston 10 is asking those questions and following the money because I'm nosy. I want to know. I have also started seeing rumblings, and we had talked about this previously, of Karen Reed signing a movie deal with Alan Jackson as part of the production. And I'm starting to see rumblings of a book deal being signed. I'm curious to see more details on that, but I wouldn't be surprised if there is both a book deal and a movie deal. And I think we'll hear more about those production deals as we move forward. Let me know if you want more information about those as it starts to come out. We're never going to know the ins and outs of the money stuff at this point, but I don't doubt that those deals have been inked. And when we're talking about fallout from this case, we need to talk about Officer Dever. And this article is coming from Ted Daniel at Boston 25. Because the Reed defense has sent a demand letter that Officer Dever be placed on the Brady list. We will be going over the entire letter from Alan Jackson on stream on Tuesday. It doesn't surprise me that there's a request here. Ted Daniel writes, a Boston police officer who testified in Karen Reed's murder retrial is now the subject of a scathing letter from Reed's defense attorney, Alan Jackson, who is demanding she be added to the Boston PD Brady list for officers with credibility issues. The letter addressed the Boston Police Commissioner, Michael Cox, and obtained exclusively by 25 Investigates, alleges that Officer Dever's credibility is irreparably compromised. Jackson's letter stems from Dever's June 2nd testimony in the Karen Reed retrial, where she said she did not observe anything unusual in the Canton Police Sallyport garage on January 29th, 2022, the day John O'Keefe was killed. Dever was working as a Canton police officer at the time and was working overtime. Jackson's letter highlights a conflicting account from the now closed federal investigation of the Reed matter. Jackson states that Dever told FBI agents that she saw ATF agent Brian Higgins and then Canton Police Chief Berkowitz in the Sallyport with Reed's Lexus for a, quote, wildly long time. In court, she recanted this, describing it as a distorted memory, adding at this point it would be a lie to state it. I said at the time of that testimony and afterwards that I thought essentially her career as a police officer was effectively going to be ruined by her testimony because she testified repeatedly that it was a false memory. That breeds credibility issues if you have someone on the stand recounting what they saw at an event when they have previously said they create memories. She said it was a created false memory. A defense attorney is going to want to question a cop on that if in the past you said something you saw was a created memory. Okay, well, if you saw person running from law enforcement and throw something in the bushes, is that a real memory or is that a created memory? I think that her testimony in the Reed case made it almost impossible for her to testify in other cases. So I'm not surprised that Alan Jackson is going a step further, saying she needs to be put on the Brady list if that hasn't happened already. So we are going to take a look at that letter together on stream, but we also now have the police commissioner essentially saying, I don't know anything about the Reed case. I'm not involved in the Reed case. I encourage all my officers. So now we have a conflict about whether or not this conversation between Dever and the police commissioner even happened. I don't know how this continues to get worse, but how does Dever's testimony continue to get worse? It's getting worse day by day. Did the police commissioner never meet with her? Does he not remember this? Is that another created memory? This is going to continue to get worse. At least most of the defense attorneys in Massachusetts are going to know if they Google this officer's name that this is going to come up. But that's not a substitute for putting someone on the Brady list, where the prosecution has to turn over this information. And when the prosecution turns over the information, it should include the reports, which includes the federal reports. She said this in this report, she said this in this report, and she said this at testimony. Those are different things. I can't imagine a circumstance where that doesn't get turned over to any case she is a party to for the rest of her career, which means Boston PD has to choose if they put her in a position where she's never taking reports and testifying in court again. And that very well may be. But who knows? If the police commissioner doesn't even know who this person is, then we'll see. So yes, we will be talking more about the police commissioner's statement distancing himself from ever having a meeting with Kelly Dever, from knowing anything about the Karen Reed case and my thoughts on that, along with the entirety of Alan Jackson's letter on Tuesday. And yes, I've been asked a lot about the motion to dismiss in the wrongful death lawsuits. We will get into the wrongful death lawsuits again in the Karen Reed case as time allows. It's on the docket. A lot's been on the docket lately. So if you don't want to miss a thing, you need to make sure that you have the Law Nerd app. It's free on iOS and Android. We built it for you so you never miss a video. Remember, the Emily Show podcast is on the Emily Show YouTube channel and your favorite podcasting app every Monday-ish, depending on travel schedule to go see my kiddo perform with the Cavaliers. But the case briefs are also on this channel when we break down things that I talk about on stream. So if you want to make sure you never miss that, subscribe to the Emily Show channel. And if you get the Law Nerd app, we will push every single video I put up, whether it's a live stream over on the live stream channel or a video here. So you will always stay in the loop. And if you want to hear the rest of this story, Tuesday at 11 a.m.-ish, I'll be live over on the Emily D. Baker channel. So subscribe to both places. You'll never miss a thing. Just get the app. However it's easier for you. Thank you for being here. Thank you for being a Law Nerd. And I will see you in the next one. Bye. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.